Good morning, everybody. Welcome again to another COVID-19 webinar, one of the webinar series we have as the National Institute for Occupational Health on COVID-19 and occupational health and safety to build capacity amongst our stakeholders within South Africa, as well as those who are joining us from outside of South Africa. Today's topic, we're looking at workers' rights in the era of COVID-19 and the workplace. And we have a number of very excellent guests today to assist us in unpacking the importance of the obligations and responsibilities and rights that is contained broadly within the legislation and the legal framework, but also as it emerges and the ongoing developments with regard to COVID-19, the directions, regulations, and other related new developments that emerge. So it is with pleasure that the NIOH, which is a specialized division of the National Health Laboratory Services, welcomes you to this webinar. The NIOH is a sister unit, a sister division of the National Institute for Communicable Diseases, the NICD. So this particular topic is very important. It is interspersed and intermingled with many of the other topics, but today we are dealing with the issue of rights and obligations and responsibilities that is legally or put in place through the legal framework and all of the regulations, directions, and so on that's linked to it to unpack that. Our first topic is on the compensation for COVID-19 and the workplace, and that will be presented by Ms. Nokutula Sihlangu. She is with the compensation fund that is under the auspices of the Department of Employment and Labor. That is followed by the topic medico-legal aspects of COVID-19 in the workplace, and that's presented by Dr. Jan Napier, who's an occupational medicine doctor and occupational health safety consultant specialized in social law. And then thirdly, we have a team from Richard Spoor Incorporated Attorneys, led by Mr. George Khan, and they are dealing with the topic COVID-19 rights and duties towards a better understanding of the law. And we'll be looking at some of the more recent developments that would be of importance for us to be aware of and to know of. Some of them obviously would be clear guidelines already emerging, and others would be in the process of, I guess, ongoing development, which we need to monitor. And so with not much further ado, I just want to do some admin with you. Please, as a reminder, firstly, the hand raising function is not working for the webinar with such large numbers of attendees. You must type your questions for the presenters in the question and answers box, and you must type your general admin or other basic questions in the chat box. Please do not raise your hands. I will let you know if that happens, and I will lower your hand in order just to keep the webinar flowing smoothly. Secondly, the key thing is to make sure that your questions are clearly typed in the question and answer box, and our facilitators, our presenters, our speakers, and the team from RSI, Richard Spoor Incorporated, would also be answering the questions as you type it there. So this webinar does provide a general attendance certificate, which is circulated after the webinar for everybody. For those who require CPD points, a CPD test will be uploaded, and a link and a password will be sent to you for those who do require the CPD points for the accredited bodies that the NIOH is associated with. Also, we will be sending out to you a link so that you can do a post-webinar evaluation and tell us with regard to what went well, what didn't go so well, and suggest any new topics that you think the webinar series should be dealing with. And then finally, we will be sending you the links for all of the presentations, as well as any resources and the video and audio recordings, which will be placed on our website. The NIOH's website is zero-rated by all of the mobile service providers and an internet service provider, so you're not going to be charged any data when you go to the NIOH's website. That is www.nioh.ac.za. And for any other general queries, you can use the info@nioh.ac.za, the info@nioh.ac.za email address. So In order then to just start, I just want to check with Ms. Shishlangu if she could just prepare her slides from her side and check her microphone or audio while I quickly secure the bio I need to just introduce. So a reminder to everybody, please type your questions in the question and answer box and your general comments and chats in or other sort of points you want to make in the chat box. So I just quickly want to secure the, one moment. Okay. So I want to introduce Ms. Nokuthula Shishlangu. Nokuthula, do you have your presentation ready?
Yes, it's ready. Thank you.
Okay, great. I'm not sure if you've answered me already and I didn't hear you. I just realized I didn't have my earpiece in my ear. My apologies.
Yes, I've got my presentation ready. Thank you.
Okay. If you could just open it up in the meantime and just get it ready to share.
All right. So will you alert me when it's time to share?
Yes, you can do that now.
All right. Thank you. Is it visible?
Yes, if you could maximize it. And in the meantime, I'm just opening the brief bio. And so to introduce Ms. Shishlangu to you, Ms. Nokuthula Shishlangu is a director that is for compensation benefits in the Department of Employment and Labor. She has been occupying this post from September 2015, approximately 5 years now. And Ms. Nokuthula's, Ms. Shishlangu's has been, job entails providing strategic direction to the claims processing team of the compensation fund. And that also includes drafting regulations, internal policies and procedures, and for processing of claims and payments of compensation, accepted compensation claims. And this also includes stakeholder engagement, as well as training of stakeholders. And then finally, Ms. Shishlangu is responsible for reporting against the approved plans of the compensation fund. And without any further delay, I'm now going to hand over to Ms. Shishlangu. Thank you very much for joining us today and making time in your busy schedule to share your experience, skills, and knowledge with our stakeholder audience. This is very much appreciated. If you could just maximize your slide.
Okay, the slide is currently on slideshow. So is it not looking better?
Yeah, we can still see the smaller slides on the left-hand side.
Okay, let me try again. Is there an improvement?
No. Can you see the full slides?
Yes, I can. So let me restart the process and then.
Thank you very much. Yes.
See if there will not be an improvement now. Is it better now or is it still?
So I can see your slides, and maybe you should proceed with the way it is now. I'm not sure if you can just check if it moves. I hand over to you.
Okay, thank you so much. As I've been introduced, my name is Nokuthula Shishlangu, and I work for the Compensation Fund, which is a branch in the Department of Employment and Labor. If I can go into my presentation quickly. so that I don't, I maximize the time allocated to me. So I'm going to take you through the mandate of the compensation fund, just to give you a brief overview of what the compensation fund is about. And then immediately after that, I'll shoot straight into how do we compensate COVID-19 accepted cases, so that you get a good view. I try by all means to make sure that my presentation is talking to how we deal with COVID-19 cases. I'm not giving you a generic presentation, but if there is a request for that, I can make it available to you, Ashraf, so that you share it with our colleagues and attendees. Now, the mandate of the compensation fund, the fund was established in terms of Section 15 of the COID Act, as we call it, the Compensation for Occupational Injuries and Diseases Act. And its main objective is to provide compensation.
Apologies, Ms. Shlango. My apologies.
Yes.
Are you already on your second slide?
Yes, I am.
Okay.
Is there a delay on my side?
Yes. No, it's not moving on our side, so I'm going to ask my colleague Tabani to share the slides from the IT side, and all you have to do is just tell him next, so that he can move the slides on your behalf. So I'm going to ask Tabani, my colleague Tabani, in the IT section, just to share that. It's possibly that there might be a delay on your side with your connection, but your audio is perfect. So a quick reminder, while we're just sorting out this, there we go. So a quick reminder, please, everybody, type your questions in the question answer box.
All right. Am I expected to activate my video? Is it perfect the way I'm presenting?
You are perfect, not necessary. It might just affect the bandwidth. Please proceed. Thank you very much.
Thank you so much. Let's go to the next slide. I've already presented the top part of the slide. I was on the main objective. The main objective is to compensate for disablement caused by occupational injuries or diseases. This is where our fund revolves around. So if a case or an incident is not related to a workspace, we don't compensate. And this is something that also clouds a lot of people's judgment when it comes to COVID-19 cases. So we'll get there. Let's move to the next slide, which talks to the vision of the compensation fund. Our wish is to be a world-class provider of sustainable compensation for occupational injuries and diseases, rehab and integration services. So like we're saying there, we want to also be sustainable. We don't only want to provide an excellent service, but we want to be sustainable, and that talks to our funding model that revolves around collection of revenue from our registered employers in the form of assessment, and then using those monies to compensate our injured employees. Next slide. The mission of the compensation fund is to provide efficient, quality, and client-centric and accessible COID services. So this has been achieved by decentralizing to 33 labor centers. So the Department of Labor has got quite a number of offices countrywide, and only 33 of them currently are able to process COID benefits. We want to also achieve our mission by sustaining financial viability, and we want to be an organization that takes care of its staff for effective service delivery. On the next slide, if we can go to the next slide, we just want you to see how we plan to achieve that. So this is our strategic plan. I won't go into detail, but it will assist those who don't have a good clue what the compensation fund is about. You will be able to see our projects there. You'll be able to see our objectives, our key performance area to help you understand where we want to go as the compensation fund and how we're planning to take the fund there in terms of performance. If you go to the next slide as well. The next slide is more details about the COVID services, medical benefits and rehab services, how they contribute to the vision and mission of the organization. If you go to the next slide. So I don't want to take much time on the overview because I need to share information with you about how we deal with COVID-19 claims. I've already alluded to the slide where I indicated that we have 33 labor centers. I was getting background there. I've already alluded to this slide, colleagues, so I'm not going to take time on the slide, but it will, when you go through my slides in your own time, you'll get to understand where we are. But in all the 126 labor centers of the Department of Labor, when you visit, there will be some form of service that you can receive. But when you go to the 33 ones where we are processing, that's where you can get a one-stop service. Let's go to the next slide. Yes, so this is where we start with the COVID-19 cases. In the next slide, we have more details. So currently the compensation fund is using a system that we call the Comp Easy system. In terms of the act, the claim is submitted by an employer or by a representative in the form of a third party. What we expect is that our employers would register on the system as users so that they are enabled to register claims into our system. We also have medical service providers or healthcare providers that also register on the system to enable them to submit medical reports and also their medical invoices for payment from the compensation fund. It's also on this system where we adjudicate the claims that we receive and prepare them for payment of benefits. If we go to the next slide. So now with that brief overview of the system that we are using at this stage, these are the documents, or this is the information that we expect on the system to support a claim. So as I indicated, the claim, the COVID Act gives power to the employer to register and communicate with the compensation fund with regards to any incident. The same power has not been given to an employee. Even our healthcare providers, currently they are able to submit only information for the purposes of supporting a claim and getting a payment. But the registration of a claim with the compensation fund sits with the employer. So in terms of the act, an employee who is injured, or in this case, who is COVID-19 positive and believes that it's a work-related case, they would report to their employer, and the employer would complete an employer's report for an occupational disease. The code for that form is WCL1. And then the employer will also provide, in support to the claim, notice of an occupational disease form that is called the WCL14. We also require an exposure and medical questionnaire that also supports a claim. This is a new form that was issued last year to assist with linking a COVID-19 positive case to a work environment. We also require a first medical report where a person was referred by their doctor to do a COVID-19 test, and we also require a work exposure history. So bullet point number 3 and bullet point number 5 look similar, but bullet point number 3 is specific to the COVID-19 exposure, and this is very important. And then we also require medical report on employee symptoms that details the history and so on to assist our medical staff to adjudicate the case. What is most critical is that we need COVID-19 lab results. Without that lab results, we won't be able to register a COVID-19 case as a work-related case. We also need a certified copy of the ID of the employee who's COVID positive. So like I said, my presentation is specific to COVID-19. Now, when it comes to South African citizens, we don't require a certified copy, because on the system, when an employer punches the ID number for a South African citizen, we are able to verify the information and confirm that we have a valid ID number, and it's linked to Nokuthula Sihlangu, and this is a date of birth. We are also able to see whether Nokuthula Sihlangu is still alive or not, and we can also use that information to check whether which institution is this person working for. So, but when it comes to non-SA citizens, a certified copy of an ID document is very critical. So what am I trying to say? For a non-SA citizen, for an SA citizen, we're not really so strict when it comes to the certified copy of the ID. But for non-SA citizens, because we don't have access to their population database, we definitely need their certified copy. Now, as I indicated, I see there are questions that are popping where we're talking, they want to know how do we link the infection to the work environment. The exposure form, that is bullet point number 3, exposure and medical questionnaire. That is where you'll be, the employer, when the employer is completing that form, that is where they will be able to link it to the workspace. So that is why the employer is very critical in this in this case. Ashram, I'll need help because I talk a lot. If somebody can alert me maybe 10 minutes before I exhaust my time so that I don't go beyond the scheduled 30 minutes. We're now going to go to the next slide. I hope our colleagues were able to understand that. So after receiving all the information that we have mentioned in the previous slide, the compensation fund takes the information, adjudicates on the claim, and decide whether to accept liability for the claim or to repudiate liability. When we repudiate, we are saying that we are not able to link this claim to the workspace. But if we accept liability, we are confirming that there is a clear link between the infection and the workspace, and therefore the compensation fund must pay for compensation. Now, after accepting liability for the claim, let me start with where we repudiate liability. Where liability is repudiated, the employer or the employee or any affected party may review the decision of the Director General, as we call it in terms of the Act. We call that process an objection process. So they can complete an objection form, provide additional information that can assist the Director General to review its decision. And upon receipt of that information, the Director General presents that information to a panel that is independent from the first team that was adjudicating the claim, and they may come to a different decision. So they may overturn their decision from repudiated to accepted. Now, these are the benefits that we pay when we have accepted liability of a claim. The first benefit, and this is more applicable to private sector employees, because the government employees continue to receive a full pay when they are receiving treatment for any COVID-related incident. So this is, I want you to remember this, that this we pay to private sector employees. Now, private sector employees, we pay them what we call temporary total or temporary partial disablement. So in short, this is what we pay you when you're still recovering at home, when you're still receiving treatment and you booked off, and in the first 3 months of your injury or your disease, in terms of the Act, an employer is expected to pay you as to pay the employee this benefit and recover from the compensation fund. After the 3 months had elapsed, the employee may claim directly from the compensation fund. Now, for COVID-19 positive cases that have been accepted by the compensation fund, this is very critical because the 3 months is treated differently. I just wanted you to understand what the Act is prescribing as responsibilities of the employer. When it comes to COVID-19 positive cases, we pay for 30 days only. That is mandatory. So we can pay up to a maximum of 40 days. And this must be supported by a doctor's sick note. So the doctor will decide to book off the client, and then we pay according to that. We only pay beyond a period of 30 days if there are complications and our internal medical practitioners are satisfied that it makes sense that this person will still require treatment after the expiry of 30 days. There is also a minimum for this, minimum number of days that you should be booked off with regards to this benefit. You must be booked off for at least 4 days. Any days off that are below 4 days, we don't compensate. But for a period of four days and above, we do compensate. We will also be expecting what we call a progress medical report from the treating doctor and a resumption report from the employer. So these are two separate forms. I hope you are able to see that we have a doctor who's always active when we're dealing with a case, and the employer is also always there as well. Now, at the bottom of my presentation, I've presented you with the calculation, with the formula for calculating this benefit, the temporary total disablement. It is indicated there that we are paying 75% of earnings. So all the time we compensate according to earnings. Earnings it's not your salary. In some instances, your earnings may be equivalent to your salary, but earnings includes your overtime. It's your salary including overtime, any benefit that you're receiving in monetary value or in kind. We also consider the allowance for food as well for farm workers, for example, whose compensation sometimes it's your accommodation and also the food that they are given there. So we consider all of that package, add it up together to come to your value for earnings. And we pay only 75% of earnings, not salary. And then if you are booked off, like we're saying there, we multiply it by the number of days off over the actual days in a month. So for example, in a month of February has got 28 days. If you are booked off for 10 days, we'll only pay for 10 days over 28 days. If you were booked off in a 31-day month and you were booked off for 31 days, we'll pay you for the full 31 days. If you were booked off for 30-day month, we apply the same formula. The only difference will be what is the number of days in that month. So some months are shorter, so the rate for the month of Feb, because it's shorter, the rate per day that we're paying will be a little bit higher because you've got fewer number of days in the month of Feb than when we're comparing it with the month of March. So in other words, I'm trying to indicate that we treat each month differently. We're currently not using an average number of days per month. We're saying in Feb, if it's 28 days, we're paying for 28 days. And if it's March, it's 31 days. We will use 31 days as our denominator. If we can go to the next slide. In the next slide, we're seeing the benefit type 2. We call it a permanent disablement lump sum. So like we said, that if you are COVID-19 positive and we accepted it as a work-related disease, we expect you to be booked off for a period of a maximum period of a month. It can be accepted only on exceptional cases that are approved by the compensation fund. So after you had fully recovered and your treating doctor, after taking you through the necessary tests and so on, discovers that you have a disablement, the doctor will complete what we call a final medical report and submit it to the compensation fund. Upon receipt of that form, so that form for COVID-19 positive accepted cases, we're expecting it only after 3 months from the date of diagnosis. My apology, I want to go back to the previous slide, even if you don't go there, but I also want to indicate to our attendees that when we pay the temporary total disablement benefit, we're paying it from the date of diagnosis. In other words, we're looking at the date of the lab results and we're saying from this date, COVID-19 was confirmed and we pay from that date. Now, as I was continuing, we can go back to that slide to benefit 2. After receiving all your temporary total disablement, we don't pay the 2 benefits concurrently. In other words, we don't pay for an overlapping period, but the first benefit may be paid from the first of for the month of February, for example, and then when you present disablement, your doctor would treating doctor would submit the final medical report after the period of 3 months, and we do an assessment for a permanent disablement. Now, if according to our assessment, your permanent disablement is between 1 to 30%, we're paying you what we call a permanent disablement lump sum. I will talk to a permanent disablement of 31% to 100% later on. Now we pay you that amount. We pay you that permanent disablement benefit if you are between 1 and 30%. The formula that we're using there is different from the first one that I was presenting in the previous slide, because now we're saying that you have reached maximum medical improvement. You cannot be treated beyond this. And then we're saying I believe the doctors understand better the terminology. That's the only time we pay this benefit. And then the formula that we're using, it's earnings again. All our formula for compensating individuals are based on your earnings. So a low income earner may not get the same benefit as a high income earner. So the earnings differentiate between who gets more and who doesn't get more. So for the same permanent disablement, a low-income earner will get low, and the high-income earner will get a higher amount. Now, the other thing that I want to share with you, we have a document that we call a Schedule 4 document. It's published annually. It's a regulation. So the minister approves it and publishes it annually. That schedule indicates what is the minimum compensation per benefit type. So like the previous benefit that I was speaking about, you'll get the minimum and the maximum benefit. So what that schedule says is that as a minister of the Department of Employment and Labor, I won't pay below this amount. Let's say for this year, the minister says my minimum for this benefit is 4,000 rand. So in other words, even if you're earning 1,000 rand, the minister will compel the compensation fund to pay the client a minimum of 4,000 rand for a full benefit. So, for example, in the previous benefit, if you were booked off for a full month, that will be the minimum for the month. If you were paid for the portion of the month, it will be that minimum multiplied by the number of days to get your portion for the month. Now, I'm on this. So I was trying to help you understand how we interpret the minimum and the maximum. Now, when it comes to the permanent disablement, there is also a minimum benefit and a maximum benefit. So if the minimum benefit in this instance is 100,000 Rand, we're now on the permanent disablement lump sum. If a minimum benefit is 100,000 Rand, if you were earning 1,000 Rand multiplied by 15, that is 15,000 Rand, that is your earnings, and you had a permanent disablement of 30%, and that gives us 15,000. Now, based on the example of 100,000, the minister has already said, I won't pay below 100,000. Therefore, your benefit will be pushed up from 15,000 to 100,000 because the minimum is 100,000. I hope that is not confusing for our colleagues. Even when it comes to a maximum, you may be a high income earner and you are earning over, let's say you're earning over 60,000, and then we're going to use your earnings to calculate your benefit. If your benefit as calculated exceeds the maximum set by the minister, your benefit, the amount that you're going to get is the maximum that is approved by the minister. I hope that is clear. So please remember that we have earnings and a salary. Our benefits are based on earnings.
10 minutes.
Okay. I thought somebody was talking to me. Can you come again?
Yeah, just saying that we were good about approximately 10 minutes, 9 to 10 minutes.
All right, thank you so much, sir. Now, there's a slight difference when it comes to those who are 26 years and older and those who are still on apprenticeship. We use what we call probable future earnings. If we can go to the next slide quickly. Now, on this slide, that is where we see individuals who have a permanent disablement of 31% to 100%. The formula is different in this instant, and the people who are getting a permanent disablement assessment of 31 to 100%, we pay them a monthly pension. So the formula for those, for calculating the benefit for those individuals is earnings multiplied by 75%, and then we also multiply that by your PD, your assessed PD. So the description of the earnings is the same for all our benefits. Now, the other information that I would like to share with you is that if you have had a claim with the compensation fund before the current claim, so let's say with your previous claim, you had a permanent disablement of 15%. With your new claim, you're getting a permanent disablement of 25%, which adds up to 40%. The compensation fund, even though your most recent permanent disablement is 25% and it doesn't take you to a level of a pension, but because you've got more than one claim, the fund will add up the two to grant you a permanent disablement of 40%, and therefore start paying you a pension. Let's go to the next slide. On the next slide, I wanted to show you that we have a benefit that we call a constant care allowance. This is for individuals who need the help of another. So normally we pay this permanently. So we don't have a short-term benefit of this kind. So we never have instances where we pay, saying we're paying for 6 months only, we're only paying you now, we're giving you this benefit because you just left hospital and you need someone to assist you because you went through a major operation. No, we normally pay this permanently. So once we approve this benefit, we pay it for as long as you live. And the minimum amount that we pay in this instance is 10% of your pension. We pay, this benefit is equal to 10% of the monthly pension you're receiving. So it's mostly received by our pensioners. And we also have a minimum amount. In 2018, it was 1,990. Right now, we're paying over 2,000 rand. If you can go to the next slide. The next slide is talking about fatal benefits. So fatal benefit in instances where an employee who tested COVID positive and the case was accepted by the compensation fund, the compensation and unfortunately they pass on as a result of COVID-19 related complication, the fund will continue to pay the dependents of the employee. So number one benefit that we pay is what we call funeral costs. We've got a flat benefit of 18,251. We pay the same amount for all our beneficiaries. We have what we call a widow's lump sum. So if the employee was married, we'll pay their widow or their widower 2 times what would have paid the deceased individual had they been 100% disabled. We also pay a pension.
Nokutula, are you there?
To those dependents, so the dependents can be, and in exceptional circumstances, who were dependent on the deceased employee. Of what would have been paid. Chairperson, are you able to hear me?
Yes, I can hear you now. Although on your, no, I can hear you now.
Okay, did you hear the part where I was speaking about the spouse?
I heard part of that, yes. You
All
may
right,
want to
so
just
I'll
to cover that.
Okay, I'll start there. So when it comes to a spouse, we as I indicated, that the main dependents of the deceased employee are a spouse and children. So if there are no children, we'll compensate a spouse. If there is no spouse, no children, we may compensate anybody other than a spouse. It can be parents, it can be siblings or grandparents, those who were dependent on the deceased employee. What I want you to know is that we calculate the benefit as if it was at 100% disablement. That would be the same as the formula that I shared in the previous slide for a pension. So if we give 40% to the spouse or spouses, so the spouses always share the 40%. So we're not giving them 40-40. If there were 2 spouses, we'll give them equal portion of the 40% that is for the spouses. In case of children, we pay them 60. They share a 60% share of that pension. So if there are more than 3 children, they will share equally the 60%. If there are 20 children who are underage, they also share that 60% portion. If there is 1 child or 3 children, we pay them a maximum of 20%. Can we go to the next slide? This is what we call a commutation of a pension. In this instance, only a widow or widower or a disabled pensioner can access this benefit. This benefit is not for children. So what happens is that someone will ask for an advance on their pension, and then we pay them a certain portion. There is minimums, and there's a minimum and a maximum that we apply when processing that benefit. The last benefit that we pay, Chairperson, is the medical aid. On the next slide. The medical aid, we have published medical tariffs, or we publish medical tariffs on a yearly basis. What I need us to know is that in this instance, because COVID-19 accepted cases, we compensating for the first 30 days, that is guaranteed, and anything beyond a period of 30 days will require approval. So if a client needs to be treated beyond the 30 days period, they will be compensated as such if the compensation fund believes that the disablement will be reduced. And that's how I end my presentation, Chairperson. Thank you so much.
Thank you very much. That was Ms. Nokuthula Sihlangu from the Compensation Fund under the auspices of the Department of Employment and Labour. Thank you very much. I think that was a very comprehensive ground that's been laid there for our other two speakers as well, spelling out in much detail what the requirements are to submit a compensation claim for occupational exposure to a biological hazard COVID-19 in the workplace. So without much further ado, just a reminder, I see some people have raised their hands. Your raised hands will be lowered in a few minutes by me. The raised hands are not functioning for this webinar. Please type your question in the question answer box. I've also seen a few people type their questions in the chat box. Please copy and paste your question in the question and answer box. Our presenters and the panelists from RSI will be looking at your questions and answering it live. Also, there's some questions I think that some of our speakers may want to deal with when they are presenting. So without much further ado, I'm now going to encourage Dr. Lapierre just to share his slides and to prepare to present. In the meantime, I'm going to do a very brief introduction of Dr. Jan Lapierre for our audience and the stakeholders. He's known to have appeared on our webinar on a number of occasions. Dr. Lapierre is a registered health professional council of South Africa occupational medical practitioner with special interest in chemical and pharmacological occupational health and safety. The SACCMP is also a registered practitioner with this SACCMP, a construction as a health and safety agent, and he specializes in as a medical legal consultant specializing in occupational health law. Without further delay, thank you very much. I see that Dr. Lapierre has shared his slides, although we could also see your notes on the right-hand side, Dr. Lapierre. I'm not sure if you just want to reshare that with us so that you can only share with us your main slide. In the meantime, a quick reminder to everybody, please use the chat box for your general comments. Please lower any hands that you've raised, and your questions for the presenters, please place those questions and type them, or cut and paste them if you already typed them in the chat box. Cut and paste and type them in the question answer box. I'm going to ask Ms. Sihlangu as well as Dr. Lapierre when he's done. And I see that Mr. George Khan has already also been answering questions in the question answer box for them, just to keep a sharp eye out for the questions that are appearing there. So at the moment, I think you're sharing your desktop, Dr. Lapierre, because there's the program as well as the slideshow there. You may have to unshare and only share the PowerPoint function.
Yeah, for some reason, it only wants to share this one here. Can you hear me?
Oh, yes, I can. So if you unshare and then just restart your share process, the share screen button at the bottom, but you first have to unshare what you're sharing now, which is, yeah.
Am I sharing my full screen with you now?
You're only sharing the slideshow, but the slideshow is showing the notes on the right-hand side. So if you click share screen again and just choose the little window that will show you only the PowerPoint application. That's it. Perfect. Full screen. So thank you very much again for joining us and taking time to share with our participants, our attendees on the webinar. I hand over to you, Doctor.
Thank you, Ashraf. Good morning to everyone. I've selected a few occupational health aspects of COVID. So we're in quite a narrow field. And I've then selected it further to go and look into what their statutory, what legal requirements there are. A little bit on case law, which is starting to develop. And then in the end, also some personal remarks. I have shared those with my colleagues and have them peer reviewed. Not everybody agrees, so that's why I left them read as they were. The occupational hazard of COVID is really limited to two large aspects. One is work-acquired COVID, which we just talked about, where an employee would contract COVID from another employee or from a customer or a visitor or somebody else. And then the second one is where an employee, which is not work-acquired COVID, but where an employee would infect another person. You can think of an old age home where a nurse would infect an old age person. So those are the two occupational risks we're talking about. They are embodied in Section 8 of the Occupational Health and Safety Act, which looks after the health and safety of employees, and then Section 9, which looks after the health and safety of other people than employees. And this is what really we're going to talk about this morning. The employment regulation has changed slightly. Certainly it's changed in hierarchy. It still remains common law, constitutional law, contract of employment, statutes, but then you can see that suddenly the National Health Act has taken the first place, where usually we were talking about the Mine Health and Safety Act or the Occupational Health and Safety Act. And then our Dr. Zuma is taking second place with the Disaster Management Act, and only then come our Standard Act. As you can see there, we're going to try and talk about the notifiable disease, the disaster directives, the regulation for hazardous biological agents, sick pay, employment conditions under the Labour Relations Act, medical testing, sick pay and unemployment sick pay, and then work-acquired COVID-19, which my colleague fortunately has covered already. So that makes me have to talk a bit faster. But before that, here's an interesting case. You can Google the case. It's really worth reading what judges say about what we're doing. And this was a case where an employee who first of all was a contact with a confirmed case still came to work, and despite having to be in quarantine, later on tested positive and still came to work despite having to be in isolation. And in the process, physically hugged people at work, didn't conform to any of the standard protocols at the workplace, and evidently was dismissed. But it's interesting, and I must congratulate Ashraf and NIOH for reminding us of what's happening, because here was what the judge says. He says, there need to be more done in the workplace and in our communities in ensuring that employers and employees and the general populace are sensitized to the realities of the pandemic. And in fact, he then says the employer needs serious introspection whether his existing health and safety measures, he calls them fancy health and safety measures, and protocols are really being taken seriously. And this is an experience I have myself. Also, it's one thing to have health and safety protocols in place on paper, but it's another one, and it's meaningless if it's not being applied. And this is what we're seeing with this fatigue about it, that a lot of the protocols are no longer being followed. The judge puts out a number of questions. I'm not going to go through those questions. They're worthwhile reading. Ashraf will make this presentation available, hence some of the slides are quite populated, and that's not because I'm going to talk so much. It's just that you can use them as a reference document if you want to, and you don't have to take pictures of them either. So what happened to us in March last year? First of all, SARS-CoV-2 became a notifiable disease. Now that's got a major impact on all our lives, never mind occupational life. And that impact comes from the National Health Act, and then later on also from the disaster management regulations. The second thing that happened is that SARS-CoV-2 was declared a medical emergency, which allowed the activation of disaster measures and the Disaster Management Act and regulations, and all the restrictions on our day-to-day lives created a new normal. It also allowed ministers of other departments to start giving directions and make laws outside the normal standard process of Parliament. And those were the directions which we work with. And in those directions, there are cross-references to health guidelines, and these are incorporated. So if you want to know how you comply, you have to have a good look at all these different aspects of what is our duty. And the first one is, and I really want to remind us as a general populace, is that under the regulations relating to surveillance of notifiable conditions, every South African must, subject to a clinical examination, the taking of a biological sample, to the normal infection controls of isolation, quarantine, prophylaxis, treatment, and must provide all information required. That was a law that was in place. So in other words, it's not for employers to decide on isolation or quarantine or what needs to happen. It's there already for everybody in the populace. There's no difference between an employee and another person. The Disaster Management Act regulations overruled some of the National Health Act regulations. And basically what they said is that no employee may refuse consent to a Department of Health informant officer to submit to a medical examination, the taking of a sample, the admission to quarantine or isolation. And if you would do that, that same official has got the power to place you in isolation or quarantine without anything. It's basically locking you up for 48 hours if that is required, and then getting a warrant later after that. So that's a major change from the regulations, which the standard regulations first required the law to take its place and then the enclosure of the person. This has been reversed now. So this is the first thing that applies to all of us, and it applies to the employee. The second thing is that healthcare providers, doctors, are also required to adhere to DOH guidelines. And I've said this before, and I'll say it again, and I apologize for my colleagues, but a doctor writing upper respiratory tract infection on a sick note without doing a COVID is not adhering to the DOH guidelines. Employers allow somebody with 3 days sick leave for a cold or an upper respiratory tract infection or an influenza on the sick certificate, and that person has not had a COVID test or has got no other diagnosis in place, that doctor isn't adhering to the DOH guidelines, and the employer should not allow that person back into the workplace. So this is the second thing that applies, is that there's no more that absolute freedom of a medical practitioner to decide what tests or what are required and what is not required. There's a prescription in those DOH guidelines. Then the employee has to transport to work. Now, as I said earlier, the Minister of Transport is allowed to make his own regulations. So this is what's in place. And allow me just to read it, that every one of our employees who comes to work with a taxi is entitled to have at the transport facility, that the transport facility where he waits, the bus stop, let's call it, that it's sanitized twice a day, that there are sanitizers there for the employees, that there are dots at 1.5 meters apart, and that it's policed that employees wait 1.5 meters apart. And
apologies, Dr. Lapierre. There's just a comment in the chat box saying that you are a little bit faint. Maybe you could move closer to your microphone.
Okay, thank you.
Sorry for interrupting.
That's fine. If it's not better, just let me know. I'm right on top of the screen now. And obviously that nobody must be allowed in those transport facilities without wearing a mask. And then when your employee gets in the transport vehicle inside the taxi, he's entitled to those things. He's entitled to have those vehicles cleaned before picking up and after dropping off passengers. The windows must be open 5 centimeters on both sides at all times. And so it goes on. There's a whole set of requirements. I don't see these requirements being met. The requirements are debatable also in that on short distance, which is less than 200 kilometers, those vehicles can be packed to 100% of their capacity, which essentially bypasses the 1.5 meter rule. I don't know why that's been allowed. I have my reservations about this, and I use this forum to also point this out to you. So on the one hand, there's a whole lot of rules which are not being followed, and then on the other hand, there's rules that make political sense, but certainly not medical sense. Then if we move into what we are now, alert level 1, we're still talking in general. Every person in South Africa now must be, one, all persons must be able to work from home if they can. There must be strict compliance with the health protocols. There must be phased return to work. There must be staggering shifts if that's required. And the returning to work must avoid and reduce the risk of infection, so that there must be screening and proper screening and protocols in place to deal with people who fall sick at work. And there's a number of people who still cannot start work. So that also already falls in our general rules that are applicable to all employees. If we now go and have a look at sick leave, there were a lot of questions about this, so I hope I can answer this with this one slide. A COVID sick employee who is obviously in isolation, because he's sick, will get a sick certificate and is entitled to the Basic Conditions of Employment Act or the applicable collective agreement sick pay. If that would be exhausted, the employee is entitled to unemployment sick fund pay. And evidently, if somebody would get long COVID and be disabled, and that person is insured through a provident fund or some other insurance, he could claim that insurance for illness. A close contact at work, in other words, the incident that initiates a work-related COVID disease case, that person must go in 10 days quarantine. Obviously, if that person gets sick, then he moves to number 1 and gets sick pay. If that person is in quarantine, our legislation currently says that although that person's not sick, he is entitled to the Basic Condition of Employment Act sick pay benefits. A close contact outside work, in other words, somebody in your family gets ill and you've been in contact with that person, that's also 10 days quarantine, and that attracts no Basic Condition of Employment Act, unless, of course, you would be getting sick and then you get the sick pay again. Work-acquired COVID, we've just seen the temporary total disability leave pay that falls under COIDA. I don't have to repeat that. And then on comorbidity, if a comorbidity causes an employee, and mark my words, to be unfit for work on account of an illness, and that is certified by a doctor to be so, then that person, by law, by Basic Condition of Employment Act, is entitled to sick pay. I also believe that person is entitled to UIF sick pay if the basic condition is exhausted. But here in Port Elizabeth, Gqeberha, where I come from, some of the Department of Labor officials have actually said that that's not the case. So I leave that in the middle to decide. If we look at the duties under the Occupational Health and Safety Act or the Mine Health and Safety Act, depending on where you are, there is a standard duty which is enhanced in the new bill also, that all work is risk assessed and a risk-based protocol is put in place. So you can see a COVID-19 risk assessment must be in place, must be documented, must be shared, and must be applicable. There must be training and inductions and displays. There's obviously the 4 rules: the no droplet airborne contagion, the social distancing at work, the ventilation, the PPE, the hand hygiene and the hygiene of the workplace, the evacuation protocols for a sick employee at work, and then obviously all that must be compliance verified and constantly inspected and applied. And as our learned judge has said, we are perhaps failing in mostly in the last point. The directions I'm not going to go through. Maybe the latest speaker might go through them, but there are essentially 17 directions that give clear indications on what the duties of the employer is in terms of COVID-19, specific for the level of the pandemic that we're in now. And every one of those duties of an employer is also a right of an employee, except of course, when it gets to the duties of the employee themselves, which are also defined in there. There is an old normal applicable here, and that's the hazard of biological agents, which essentially says that, you know, if an employee is exposed to an identifiable disease and there are techniques appropriate to the diagnosis of that illness, and there's a reasonable likelihood that that disease may occur at the workplace, then that employee must be under what is termed medical surveillance. Let's call it medical supervision in the workplace. I think in many instances that doesn't happen at all. Now, our Department of Labor has put out 4 levels of likelihood: a very high exposure likelihood, a high exposure likelihood, and a medium exposure likelihood. In fact, in the Department of Labor directive, it's clearly indicated with good examples. For instance, very high exposure, that would be doctors and nurses working in an ICU where you inspect people's lungs or you change tubes in people's lungs who definitely are COVID positive, or morgue workers performing autopsies. High exposure work is your standard all medical personnel that's maybe acutely exposed. And then medium exposure workers, I find very interesting, that's for instance, all your supermarket tellers, where those people are. They are medium exposure risk jobs. Now, medical surveillance must exist of an initial medical examination of all employees exposed. So I wonder how many of the supermarket chains are actually doing this for their tellers that are working there with the public all the time. Obviously, the comorbidity evaluation of vulnerable employees will come from that. We've got this thing isolated as a special duty in any case. And then also the return to work after illness, specifically after COVID illness. The medical examination, this initial medical examination, is actually defined as taking a medical and occupational history, a physical examination, and any appropriate test. And then the doctor must certify that person fit or unfit, or fit with conditions, certain things that have to happen, or fit with restrictions, certain parts of the job the person can't do. Obviously, we will at the end of my chat this morning, we will also talk about, could we recommend COVID-19 vaccination? Our new directive has also defined specifically on the vulnerable employee. And it says that employers must identify those employees, and employees must disclose their health issues, comorbidities, or conditions of vulnerable employees. Nobody has to tell the employer what's specifically wrong with that, but every employee must let the employer know that you suffer from any of those conditions that are listed, they are legally listed under the NIOH guideline of those conditions, and that your employer must then take special measures. In fact, the first measure the employer must do, and again, my doubt whether that is happening, the employee must be assessed by a doctor. It can be the treating doctor. It can also be an employer-designated occupational medical practitioner who knows the workplace, and then who can write a confidential report to the employer. Once again, it's not important that you put in which vulnerability it is, but it's very important that you assess that vulnerability versus some other factors. And then the employer must take special measures. Either that employee must be allowed to work from home, or there must be some extraordinary measures taken to facilitate the return to work. Those extraordinary measures in the NIOH guidelines are actually listed with quite a few examples. You've got them here, you can read on them afterwards, but it's not as if this is a futile exercise of just doing this test and getting this report and filing this piece of paper. There must be action thereafter. So what maybe one of the correct things is for every employer is to have a vulnerable employee management procedure together with their doctor, which is to identify and assess vulnerable employees. Also at that time for the occupational doctor to be able to communicate and educate the employee, and also to protect and manage the vulnerable employee in the workplace to the best of everyone. The applicable legal references should be put in the procedure, and the definition of vulnerable employee as it comes from the Department of Health might have to be adapted. What's critical here is that some employees, I'll put it blunt and crude maybe, but some employees will consider this whole objective as one of two options. Either I die from COVID because I'm so vulnerable, that if I go to work, I might be exposed and I'll die from COVID, or I'll stay at home and I'll die from hunger. So there must be an intelligent balance between the biological SARS-CoV-2 health assessment and the psychosocial loss of income health assessment with exposure probability and severity of what can happen. So the process would be a pre-test information to the doctor, clinical assessment by the doctor, an assessment of the biological risk level by the doctor, and assessment of the psychosocial risk level by the doctor. So the balance then will come in reporting. The probability of exposure, those 4 classes of Department of Health, will have to be juxtapositions, will have to be put placed next to the probability of C19 complications. Arbitrary, we, for instance, use 4 levels. We use low risk, that's a single health condition which is well controlled, an intermediate risk, a moderate risk, and a high risk. And so we then finally would institute a report that looks like this, where essentially we say to the employer, your employee was submitted, and the objective of the examination is placed there. And then in this particular case, for instance, the employee has mobilities posing an intermediate risk. So it's then for the employer to go and look at those modalities that we saw earlier on. I said earlier, it was not only the initial medical examination, but the comorbidity examination. It's also the return to work after sick leave. There are mandatory isolation periods of 10 days in mild COVID disease or 10 days after recovery from complicated COVID disease. So those days are quite clearly set. But there should be an assessment of sick certificates prior to return to work. I say in red that all sick certificates should be assessed, not only because, unfortunately, our colleagues are not always trustworthy in sending people back to work which shouldn't be at work, but also because employees might be running out of sick leave and might have presenteeism and come back to work whilst they're not completely recovered. So that should include an assessment for fitness to work. And then there is obviously in our regulation, there are specific requirements for employees returning after COVID in terms of compulsory social distance, monitoring for 21 days, the wearing of a surgical mask, and so those things must be put in place also. And then lastly, vaccination and occupational health. And I'd like to just have a look at, the place of vaccination as an occupational health control measure in the current level of our epidemic. Could COVID vaccination be a statutory requirement? In other words, could it be legalized that everybody must be vaccinated to be at work? Could it move from statutory to case law? Because in case law, we have a thing called inherent job requirement. And that would then really mean that unless you're vaccinated, you can't do the job. Or could it be something else? And there I propose a vaccination policy. Ashraf, am I all right for time?
Yes, it's fine. I mean, you can use another 5 minutes.
Okay, thank you. So in order to offer risk containment remember those 3 occupational health risks we discussed right at the beginning: an employee getting infected by another employee, by a customer, or an employee infecting a customer. In order for these 3 risks to be contained, there's 2 conditions. The vaccinated employee must return to work and he must be immune to getting infected, and he must also be non-contagious to others. Obviously, no vaccination will offer that at 100%. So if we now have a reduced effectiveness, then the impact of vaccination on the single employee and on the cohort of employees will also be reduced. And then eventually you'll get to such low effectiveness that you'll start questioning whether the process itself is worth the risk. Now, there are an immense amount of false news videos going around about the vaccination risks. I have the fortunate position to be involved in the safety of vaccination production. And I can assure you that at this stage, what we have in hand and what SAPRA has also registered for us as vaccines, that both the acute and the long-term side effects are very, very low. You've all seen the few disasters that we've had with these massive cerebral thrombosis, but these are very, very, very far and few in between. But what there is this is all brand new. We've never used mRNA, the Pfizer technology, for any other vaccine. We have very limited adenovirus vaccine experience. I mean, there's only one other vaccine out like that, it's the Ebola vaccine, and we have nothing in long-term knowledge. So we always got to respect the fact that there is a risk, the risk of the unknown, which is an awkward risk to deal with, but we need to consider this, particularly when we want to make something into law or into a fixed workplace rule. Now, every workplace has got the following framework of risk assessment. Right on top, it looks at the hazard identification. So we're looking at the SARS-CoV-2 hazard in the scope of work. We looked at the probability of that in those 4 classes. Evidently, the severity comes with the comorbidities. We look at the COVID risk with employees, and we look at risk elimination. I mean, working from home is obviously a very good risk elimination in terms of workplace infection. And then we're looking at risk controls. Risk controls would be on the engineering side, for instance, having adequate fresh air into the rooms, or on the administrative side. And there I've taken the liberty, okay, obviously the workplace organization, the way you enter the workplace, the screening at the workplace, the social distancing, the cleaning, all that is number A. Number B would be the applicable safe work procedures and the training thereof. D would be the medicals that we've discussed. And then E, one would question, you know, would vaccination come into as a risk containment control here in this place prior to PPE and inspection? Obviously, inspection means the ongoing verification of compliance. So just a few thoughts on that. You know, if we were to place the vaccination in the hierarchy in the prevention of work-acquired COVID-19, if we placed it before implementing other C19 interventions, then the vaccinated employees could work in risk-probable circumstances without all our current rules. So I think that's probably unlikely. If we place the vaccination after implementing other interventions, the standard interventions we have now, then vaccinated employees would still be following the non-pharma controls. But then, of course, you know, what's the vaccine effectiveness in these circumstances? Because the reduction, would there be a reduction in incidence in the COVID-19? In other words, non-pharma controls are really, really very efficient. So if you want to lower in something that's very, very efficient, that's not likely that you're going to see this. If COVID-19 vaccination was said to be preventing transmission in the workplace, then it would be essential that we do this in places, particularly in places where vulnerable persons are being handled by employees. I gave the example of the frail care or the old age homes. So if vaccination would show that it reduces transmission in the workplace, then arguably one could say, well, everybody working there must be vaccinated. So obviously we're waiting for the answers to those questions. So if it had to be a legal requirement, it'll have to match the paradigm of reasonably practicable, which is a little bit like the reasonable man. It's got 4 aspects to reasonable practicable, and if we apply them here, with non-pharma controls in place now, the severity and the scope of work-acquired COVID is already very low. I'm pretty convinced that most COVID infections in the workplace are caused by persons not following the non-pharma controls. Current knowledge on the C19 vaccination efficacy and effectiveness and impact is limited and may not be sufficient to, at this stage, enforce vaccination. This is a dated slide, of course. As we get more information, efficacy will come from further trial information. Effectiveness will come from what happens in real life with persons that have been vaccinated, and impact, obviously, we will see what happens to the workplace once everybody starts being vaccinated. And obviously, you know, at this stage, as I said, we have formal controls that do the job right. It's interesting also that if it had to be a statutory duty to vaccinate employees for COVID, then why have we never done this for hepatitis B vaccination? Moreover, because with COVID, you can see 50 and 60% effectiveness of vaccination, whereas in hepatitis B, that's a registered vaccine at 98 to 100% protection against hepatitis. That's a World Health Organization reference. Could it be an inherent requirement of the job? Now, inherent requirement of the job come from case law. And in case law, it's said that it's an inherent requirement of a job if it's a permanent attribute or a permanent quality, which is an essential, intrinsic, and indispensable attribute that's linked in an inescapable way to performing the job. If we accept the above legal interpretation, then it may really be difficult to say that COVID-19 vaccination is an inescapable way to perform the work safely. So we might not meet an inherent requirement of the job, albeit that there's a COIDA regulation out that looks at the possibility of this happening one way or another in future. And then my last is, let's have a vaccination policy proposal. And here are the 3 lines of the vaccination proposal. It's the employer considers that COVID vaccination is an employer's occupational health duty and that resources for the vaccination must be provided. The occupational health and safety risk assessment will determine whether there are instances in which a COVID-19 immunity protection of employees is a job requirement, not inherent, but a job requirement, an ad hoc job requirement for where you work. And then lastly, employees' autonomy over their health and vaccination state will be honored, and no employee shall be forced or coerced into consenting to COVID-19 vaccination. You can work this policy out here further. I've worked it out further here into some more detail, but that can be open to discussion, and you can read that at your own leisure. I thank you, Ashraf, and back to you.
Thank you very much. That was Dr. Jan Lapierre, occupational medicine doctor and occupational safety consultant with a specialization in social law. Dealing with the topic medico-legal aspects of COVID-19 in the workplace, I'm going to immediately hand over to Mr. George Khan, for whom I owe an apology for misspelling his surname, having had a good look at the emails again. George and his team is going to deal with the topic COVID-19 rights and duties towards a better understanding of the law. And there are 2 colleagues, I think only one might be online at the moment, unless they're both there, I'm not sure, who is supported the process of preparing the presentation that George is going to activate for us, and as well as supporting in answering our questions on the question answer box as well. So by way of introduction, George, if you could share your slides, thanks. So George Khan is a senior associate at the law firm Richard Spoor Incorporated and Associates, and he has practiced law for more than a decade, specializing in health and safety and its related compensation. Related compensation aspects, constitutional and administrative law, complex litigation, and has been directly and indirectly involved in numerous important judgments over the years. So George read for his science degree at the University of Cape Town, and then further read for his humanities and law degrees at Rhodes University, and further read postgrad advanced administrative law, information law, and human rights in business at Wits University. Mr. Khan has majors in law, philosophy, politics, psychology, and molecular biology, with minors in economics, sociology, history, and a variety of other science and medical subjects. I just want to say the following as in conclusion, is that George Khan is assisting Professor Paul Benjamin in updating the commentary on the Occupational Health and Safety Act and the Compensation of Occupational Injuries and Diseases Act. He is joined by Tankiso Mokwetsi, and he's a first-year candidate attorney at Richardspoor Incorporated. And before joining RSI, he read his LLB and LLM in labor law degrees at the Northwest University. I'm just going to keep that a bit brief. It does focus on some of his areas of interest. The other colleague is Godnos Mudumu. Mudimu is a first-year candidate attorney also at RSI, having read his social science and law degrees at the Rhodes University. I'm going to pause there and hand it straight over to you, George. Please proceed.
Thank you very much for that introduction. Thank you, everybody, and thank you for inviting us to do this presentation. It's a very important issue. I've already got up on the screen the outline of what we're going to be discussing today. You can see in terms of introduction, we've actually gone through a little bit of what is there. I'm going to explain a little bit why I'm doing this in the way I'm doing it, because it is important in terms of not only the COVID concept aspects that we're dealing with, but also just in general, the way lawyers work and so forth like that. Let's just proceed. Okay. What is important in law is it's also very important to always understand who it is that you're listening to and what it is that they're saying. It's very important to understand the qualifications of the person so that you don't just take things for granted. I know I'm probably speaking to the choir in this regard because you've all logged onto the National Institute of Occupational Health, which is obviously the pivotal institution in our country that deals with these kinds of aspects. But it is very important to always ask the question, if someone is saying to you something, ask the question, who is this person? What qualifies them to be able to say what they're saying, and how likely it is that they're going to be correct based on their experience and their background. In this regard, it's important for us to also introduce ourselves. As is indicated, I'm from Richardspoor Attorneys. We are a public interest law firm that specializes in human rights relating to occupational health and safety. We're probably most well known for our work in the class action against the gold mining industry, where mine workers were diagnosed with silicosis. We've also more recently been involved in the application with relating to COVID-19 on behalf of AMCU, where we got the Department of Minerals to gazette guidelines relating to the mine and COVID, which was very important. We've obviously been involved in numerous other issues that relate to these fields, including aspects of strict liability, which is maybe important for COVID as well. We've got offices in Johannesburg and White River, although we are a very, very small law firm. We frequently act on a contingency and pro bono basis. There's a bit of a joke there about the fact my boss offered to represent Jacob Zuma pro bono, but we frequently do this kind of work on behalf of all sorts of clients, not just former presidents, but also struggling housewives and widows and so forth like that. Our ambition is essentially to be a human rights law firm. Okay, we've already discussed a little bit about who I am, which is fine. What is important for you to also understand is the fact that I have a law background, but I've also got a bit of a science background. I grew up with occupational medicine in the gold mines. My father is a fairly well-known occupational medical doctor down in Welkom. And this is sort of where I sort of grew up into. Okay, as has been pointed out, I am assisting Professor Benjamin, just trying to update the current COIDA commentary and the OSHA commentary in light of the current bill that's coming out. I am joined by my candidates, which we've already dealt with, so I'm just going to quickly go through this very quickly. What hasn't been mentioned is the fact that my last candidate attorney here has actually got his doctorate, what's been conferred later on in this year. In terms of the agenda that we're going to be going through, we've already dealt with the presenters. I'm then going to touch very briefly on the sources of law. The previous speakers, to a certain extent, have already dealt with this. I'm going to try and go through it very quickly to ensure there's no repetition. I'm going to have a little bit of a discussion about the context about what we're all talking about, and I'm going to go into the specific rights that are important. I'm going to try not to concentrate on specific sections and specific directives rather than the conceptual things, which I think is more helpful. What we have provided, and I'm sure will be provided to all the parties, is we've constructed a bundle of sources. So I don't like it when someone just refers to me in a particular section. I want to be able to be given that section so I can see for myself what it says and I can understand the context of it. For that regard, and I must apologize again to any lawyers out there that may have already read this stuff, and I apologize as well to the non-lawyers, because the bundle is about 1,500 pages long, but essentially it is just the documentation that you can have as a reference to look at all the things that I'm going to be talking about. When I mention a case, we're going to provide you with a copy of the case, so you can also go and familiarize yourself with it. Okay, I would say to you that the people that deal with these kinds of issues should be sort of have these things in their back of their mind, and they should be somewhat familiar with them. There is, however, also a very excellent resource from, I think it's due to LexisNexis by ENS, where they provided a sort of a summary of all the pertinent documentation relating to non-mining COIDA aspects, and I would recommend anyone who's very interested can maybe go out and purchase a copy of that as well. Right. Okay, what is important is always to understand where are you getting what you're saying from. So it's no good just simply saying, well, this is what the law is. It's very critical to understand where does it come from as a resource. The reason why we have law is because sometimes it's difficult for ourselves to understand what it is that we need to do. Not everybody can be a philosopher or a scientist, so we need to have some sort of source that we can look to with certainty to understand what we are meant to do in terms of our conduct. In terms of the law, the first and the last word of the law is always our Constitution. Now, what our government has decided to do in terms of its approach is not to bring about a state of emergency, which was one of the possibilities, which would have actually impinged a little bit on the Constitution and the Bill of Rights, but rather to work on the Disaster Management Act, which doesn't affect the Constitution. So the Constitution is always and foremost the first and the last issue in terms of all of these questions. At RSI, we've got a little bit of a different perspective on all of the COVID things to maybe some of the other big law firms out there. I mean, you've heard a great deal of concentration and focus on the Labour Relations Act and the Basic Conditions of Employment Act, and sort of as a starting point. Our position, however, is actually a little bit the other way around. We actually find that the starting point must be the occupational statutes themselves, the occupational health and safety statutes. In this regard, in terms of non-mine working aspects, we have the Occupational Health and Safety Act, and I've listed there some of the regulations that actually already exist under that legislation that may be applicable to what COVID. And as you can see from those regulations, there are many of those regulations that are in fact quite old, some of them dating back all the way to 1986. I'm not saying that the entire regulation is important. In some cases, it's simply one specific clause or one specific subsection. But the point I'm trying to make is that if you were to be familiar with all of this stuff already, and I suspect that most of us aren't, if we were already familiar with all of this stuff, what we'd be dealing with now would be far less of a culture shock, to be very honest with you. I mean, for example, the Hazardous Biological Agents regulations from 2001 actually deals with a lot of COVID aspects already. It talks to the question of social distancing and all that sort of stuff. Then in terms of mining, we obviously have the Mine Health and Safety Act. There are slight distinctions between them. The Mine Health and Safety Act is obviously the newest statute. What is important to understand is, although there are hazardous biological agents regulations under the OSHA, they are not binding specifically under the Mine Health and Safety Act. The Minister has never gazetted anything to make them binding. However, that does not mean that they can simply be ignored. They must have some regard to them because they still have quite persuasive influence. What we have mentioned already is part of our firm's contribution is that we assisted in trying to get the department to institute these code of practice and guidelines for the mitigation and management of the COVID-19. I'm going to deal with that a little bit as well, a little bit later on as well. Okay, obviously we've had the department coming and speaking to us about the COIDA. What is going to be important and what I'm going to sort of just mention on which hasn't been dealt with specifically is that there is actually a presumption clause in the COIDA that also relates to a lot of the questions I've seen on the chat feed. So for example, a lot of people are asking, well, how do you know when something is occupational or not? Section 66, Schedule 3 of the Act actually deals with this question. So basically what it states is that if you have an infection from an infectious disease and you work in an occupation that is high risk, then it is presumed to be occupational unless someone can rebut that presumption and say, well, actually not in this particular case. The difficulty is going to be is that we seem to have a little bit of a conflict between what the different departments are telling us. So, for example, it's already been alluded to that the Department of Labour has issued a directive under the Compensation Health, which indicates, as has been pointed out, the 4 categories of exposure risk: very high, high, medium, and low. Now, in terms of Section 66, the presumption clause, we would expect that presumption to kick in around high and very high. Medium risk, you would expect there to be something else in addition that has to be put forward. A doctor would have to motivate to the fund or Rand Mutual, whoever it might be, why this particular infection is occupational. It can't just be assumed to be so or presumed to be so. The difficulty is that the DMR, in terms of its guidelines it's published, actually suggests that, well, an underground mine worker who may, for the purposes of the Labour Directive, fall under medium risk, the Department of Labour has recognised that those workers are in fact still high risk. So there's a little bit of an issue there. No one has actually dealt with it yet. I'm just highlighting it, that there might be an issue. I suspect that what's going to happen is that the compensation fund would probably respect the expertise of the Department of Minerals in this regard and accept that maybe the presumption triggers there as well. Okay, I mention the Occupational Disease in Mines and Works Act not because it's applicable to this case, and it's very important to understand that it's not a compensatable disease under that statute, but to highlight in the instance where mine workers have comorbidities, for example, severe emphysema or chronic bronchitis, when that disease has been diagnosed while they were still at the mine, those mine workers are entitled to medical assistance from the employer in that regard. It's one of the few instances where there's a constitutional horizontal application of a social security right. And my feeling and what I've explained, what doctors have told me, is that essentially is if we can control and manage comorbidities, that also improves the likelihood that the person is not going to suffer from the worst severe conditions and complications from the COVID if they do become infected. So it's important for mine workers to understand that if they do have one of these comorbidities and they are under the ADIRMA, that they can possibly look to the employer to say, well, help me with this disease, get it under control, and maybe it won't have such a grave implications of what it might have otherwise. It's already been mentioned, the fact that there's the Unemployment Insurance Act. I just mention it once again. Again, the Basic Conditions of Employment Act. What I do just want to stop and highlight here, which is also a question that's come up in the live questions feed, is in terms of the issue in terms of sick pay. What is critical to understand is that if an employee contracts an occupational disease under COIDA, that disease does not have deducted from it sick leave. Sick leave is only for non-occupational diseases. The moment any worker incurs any kind of occupational injury or diseases, it has nothing to do with their sick leave entitlement. You can't touch that as an employer. That has to go through the COIDA process or the ADIMWA. Okay, obviously we've all mentioned and we're familiar with the Disaster Management Act. I've simply listed some of the applicable regulations there, so we're all familiar with that. Okay, what is critical important, and I think the previous speaker has touched on this, and I'm very grateful to them for that, is that the common law still is in effect here. And what is very important for the purposes of COVID, is that the common law has certain rights and duties in it that you won't actually find in some of the other statutes. So, for example, the Mine and Health and Safety Act specifically codifies the right to refuse dangerous work. Okay, there's no equivalent section in the OSHA. Okay, that does not mean that non-mine workers can not refuse to go into a burning building if their office space is on fire or something like that, but that right falls under the common law. Okay, so the employer always has a duty to try and care for their employers, and the corresponding duty of right to that, because whenever there's a duty, there's always a corresponding right, is that the employee has the right to refuse when they fail to do so. Okay, so they can refuse to go in. What is also important, and this is where it might be applicable to COVID more also for mine workers, is that the common law duty to refuse dangerous work is in actual fact broader than the statutory duty located under the Mine Health and Safety Act. The reason why I say that is the Mine Health and Safety Act refers to the right to leave the workplace, meaning that essentially you need to arrive on the premises, identify the issue, and then leave. The right to refuse dangerous work is a slightly more nuanced, a little bit broader than that, meaning that if you know that there's going to be a danger there, you don't need to arrive on the premise first. Okay. What is also important in terms of the common law is to understand that COIDA, although COIDA does grant immunity to employers if a worker does become sick, that immunity is not overriding an absolute. There are very limited exceptions to that rule. So, for example, if you employ people through labor brokers, the labor broker, strictly speaking, is the employer, not the principal. So in this case, what you may find, and there is case law on this, where the person or the company that employs workers through a labor broker, they can actually be sued under the common law. Section 35, which is normally the section that grants the employers immunity, doesn't come to their assistance. What we need to understand about COVID and the law here is we're dealing with a public interest matter. It's a public law matter as much as it is also a private law matter. What we're trying to deal with is we're trying to understand what is it that we're going to try and do for everyone in the grand scope of things. In this regard, we may find that our liberal rights, and liberals are sort of another way of saying individual rights, may to a certain extent curtailed. Okay, that doesn't mean that that's unconstitutional in that regard. It means that we need to accept the fact that the interests of the community are going to be paramount at this point in time, because without the community's health, the individual health later on is going to be diminished. So we need to do what we need to do in terms of the law. So you might not like wearing your mask, and you might say, well, it's not applicable to you. You're not wearing the mask for you. You're wearing your mask for the next person and the next person after that. That's why we're doing these things, and that's why the law is there. Okay. What is important to understand is that, as I pointed out, there is a lot of legislation already dealing with the code. So, for example, the hazardous biological agents regulations have been around for 2 decades by now. What our government, however, did in terms of the disaster management is they basically used that legislation to essentially bring certain types of legal principles that may already exist to the forefront, that we'd be familiar, so sort of putting them in bold, if I can call it that, and also trying to fill in the gaps between. So there are certain places where there are missing problems and stuff like that, and they've used these thorough powers to essentially circumvent the long process that would be required otherwise to try and fix the problem, to try and do it very quickly. Of course, what's going to happen eventually is the Disaster Act is going to sort of fall away once that declaration doesn't carry on, and eventually we're going to go back to the old legislation. What we may need to do is have a further discussion about how do we set up the existing legislation to deal with these problems more coherently, more robustly in future, if and when the next pandemic occurs, so that we are not in the situation where it's a bit of a shock to our system as it is now. Okay. What is also important to understand, and this is going to be important for the next set of slides, is that employee rights, the right to refuse dangerous work, and all of these things must be measured through what we regard as an objective lens. What that means is we look at it through the eyes of a reasonable person. So it's not about what you find subjectively in your personal opinion. So, for example, you might find that you are terrified of spiders, and there might be a spider in the workplace. That is not going to entitle you to exercise the right to refuse dangerous work because you have a phobia about spiders or something like that. It must be done objectively. And this is where it's going to be very important for experts to come into it. So the doctor previously, in the previous presenters, explained a whole lot of things to you. What I'm going to say to you essentially is, when in doubt about any of these things, go and ask the doctors. Go and ask the health practitioners. They are the ones with the understanding that's going to fill in the gaps. Okay. Understanding in terms of where all the stuff comes in, as I've explained, our position is slightly different. We don't focus on the Labour Relations Act. We don't necessarily think all the tools to resolve all the COVID issues rests there. I mean, there might be some very useful things there that help us a great deal, and we certainly cannot ignore it. But we think that the actual tools that need to be focused on from the employer's perspective is in the Occupational Health and Safety Act and the Mine Health and Safety Act, together with the applicable common law relating to that. You can see in the slide, for example, we point out that in the hazardous biological agents, COVID is actually identified, well, not COVID, beg your pardon, but the coronavirus is actually identified specifically. What is novel here is the fact that the coronavirus in that regulation is identified as what they refer to as a category 2 hazardous biological agent, meaning that there are treatments for it. It is a problem, but it can be controlled. What happened with COVID essentially is that we then eventually went up to a category 4 problem, which basically meant that it was fatal, it was devastating, and there was no effective known treatments as a prophylactics to it. We now, with the vaccination, may have in fact reduced it down to what would be regarded as a category 3. But the point is the law has got an understanding of where we sit with all these things, okay? What is important for any manager or HR person who's interested in understanding a bit more about these things is it's critical to try and ask the question when you're getting legal advice or you're getting medical advice on any of these kinds of things, is to ask the question, how much does this person know about this field? Is this their main field? So I've got a lot of labor law colleagues who are very interested in giving their opinion on this sort of stuff, but they've never dealt with these kinds of issues before. With the utmost respect to them, I don't necessarily think that they're always going to be correct. You just need to maybe check that with them. At the same time as I would say to you, I'm certainly not a labor lawyer, although I'm often mistaken to be one. I'm a health and safety practitioner. So it's always important to ask, who is the person who's giving you the advice? What do they actually know about this, and what kind of qualification experience do they have? Okay. All right. One of the big issues that happened last year in our law is there was this big question about where does COVID sit in terms of the medical jurisprudence. And what I mean by that is it an occupational medicine issue or is it a public health issue? Now, what happened last year is several of the departments took the position that actually it was a public health issue and it didn't really have anything to do with occupational medicine. Our courts have now come in, beg your pardon, our courts have now come in and actually asserted that that's not correct. There is a fundamental overlap between health and occupational health. And in this regard, it is very important to understand that when you're dealing with occupational medicine issues, you need to also bear in mind the community position and the human nature of people. As we've already indicated, alluded to before, there is an issue in terms of risk assessments. And the point of that is essentially is that you need to have an objective assessment of where you are. So if you have an utmost fear of flying, that's not necessarily an objective risk assessment saying, well, you're going to die on a plane, because planes are frequently far more safe than any other form of transport. That would be a subjective view. That is not going to cut it in terms of occupational health and safety assessments. But at the same time, and this is where I'm going to pause and try and emphasize, is that the employees are frequently in a very difficult position. Employees, especially when it comes to these things like these invisible illnesses that they can't necessarily see. So, for example, the dust that they might be exposed to underground in a mine, or the virus particles that are floating around in front of them. They don't necessarily have the information that would advise them whether a circumstance is or is not safe. In that regard, there is a great deal of emphasis on the employer to take the fundamental role in that regard to ensure that it is made safe. The difficulty, of course, and this is what I must inform everybody so they're aware of it, is presently under our law, the onus of showing that there is in fact an unsafe situation presently resides on the employee. So if an employee is going to, in terms of our case law, say, well, they're exercising their right to refuse dangerous work, they're not coming into work because they're on strike, they're not coming into work because it's dangerous. The onus is on them to establish that is correct in order to trigger the right. Okay, I mentioned here the case that deals with the issue. It's the main case on the fact. I'm not entirely sure that I agree with this case in the present circumstances. I actually wonder if the judge had been had in mind COVID and these kinds of things, whether he might have been a little bit more nuanced in what he was saying. I can certainly understand maybe in terms of the physical injury danger, that sort of thing, maybe this is the correct position. But I suspect that maybe we might need to sort of ease on this a little bit going forward in terms of these invisible viruses and dust measures and all these medical issues. Okay. As we've been stating, you have the right to refuse dangerous work. I've already explained the fact that the right is not simply a statutory right. It has been codified in the Mine Health and Safety Act, but it does actually exist and continues to exist under the common law. In fact, the common law, as I've emphasized, is actually broader than the statutory thing. So in terms of the statute, you need to at least be at the premises, identify the problem, confirm that it's objectively dangerous, and then leave the premises. The only maybe sort of aspect to that is in terms of the health and safety representatives, is that they have the authority to direct an employee to leave the premises without necessarily the same level of justification. They can basically say, well, look, we subjectively view, in our opinion, although it needs to be a measured subjective view and it can't be completely outrageous, that the employees need to leave. Okay. As I pointed out already, the test is obviously always going to be objective, what a reasonable person would understand, what a reasonable person would do. And what is very important to understand is that although it derived from the common law and it's now in numerous statutes, it's in one statute, the right is bolstered by the Constitutional Bill of Rights, which entitles everyone to a right of environmental health. So if I could just pause to also indicate all the statutes and all the regulations and sources of law that I've mentioned so far, in some manner or the other, are actually all constitutional law. I haven't referred to anything that I can say is sort of definitely non-constitutional law in the regards that, like maybe the Pensions Fund Act might be regarded as unconstitutional. Every statute that I've mentioned has an aspect of constitutional law and draws a great deal of its power and emphasis from the Bill of Rights. Okay. Along with the right to refuse dangerous work, it is also important to understand that employees also have a duty not to contribute to making it worse. So in this regard, in the Bill of Rights, we often talk about sometimes vertical and horizontal rights, meaning, or application, meaning that the vertical right is a sort of a relationship between an individual and the state. Similarly, we have a horizontal thing, which is the Bill of Rights is applicable to individuals themselves. So, and that doesn't necessarily have to be a human being, it could also be a company. Similarly, with employees, we have that duty as well. And what has happened is we've recently encountered some case law. One of those cases has already been mentioned by the previous speaker, so I won't dwell on that too much. But in one arbitration matter, there was a dismissal when someone was dismissed because they basically said that well, they didn't know what their COVID result was yet. They were suspected, but they decided to go into work anyway. That, in fact, what that did is they basically endangered all the other potential employees that they had, all the other colleagues and so forth like that. And that became a serious problem. The dismissal was regarded as fair. So we need to understand it's not just for the employer to keep the employees safe, but the employees also have a part to play in that. And they need to make sure that they keep everyone safe around them. What is also furthermore important to understand is that employees also have a responsibility to the employer, because in the event that the employee makes someone who's not an employee sick, and this could be a consumer, it could be a customer, it could even be a third-party contractor, the employer may in fact end up liable for that responsibility as well. I've already pointed out and alluded to that Section 35 of COIDA does not grant immunity to an employer when that employer is not the direct employer. It may only grant immunity to the labor broker. So in a situation where you have someone who comes in as a contractor and they get sick, you may not have the immunity so that they might be able to sue you. There is an issue, but I must highlight now that it is a bit controversial at this point in time, and it is presently being challenged in the Gauteng local division, is that there's a concept of strict liability under the OSHA. What that means is ordinarily lawyers would have to establish that the wrong party is at fault or blameworthy for the conduct. It can't simply be bad luck or an accident. It has to be blameworthy. Now, what strict liability does is it basically sidesteps that whole issue. It says, well, so long as you did something that was illegal or wrongful, so you broke a statute, you didn't follow a regulation or something like that, and harm occurred from it, we don't enter into the debate of whether you were blameworthy or not. Most people typically understand this when it comes to dog bites. So if your dog races out and you do everything you can to try and stop the dog, when the dog goes and bites someone, regardless of the fact that you try to do everything in your power to prevent it, you're going to be held liable for the dog bite. Okay, and similarly in terms of mines and factories and so forth like that, foreign jurisdictions under the common law, other foreign law, common law jurisdictions have actually adopted this principle of strict liability quite strongly, because they recognize that these mines and factories may, to be a certain analogy, be analogous with that sort of scary dog, if you can call it that. Right, so this is dealing with an issue that a lot of people have been asking questions about, or sort of touching around, not realizing it. So what I need to explain is that in terms of health and safety and business profits, health and safety is always foremost, okay? We have this concept of reasonably practicability in our law. It exists in the OSHA and in the Mine Health and Safety Act. The difficulty is that our courts have not really gone very much into it, partly because employers typically have immunity from an employee who gets sick or injured because of COIDA. So we haven't developed it as much as the foreign courts have. However, when we look to the foreign courts and ask the question, what does reasonably practical actually mean? What it tells us is that there's a, as they describe, a balancing act that must be achieved by the employer. And what that means is essentially is you need to measure the cost in terms of inconvenience, money, and time to prevent a particular type of harm, and then the harm itself on the other side. If the harm is fairly trivial, then if it's going to be quite expensive to do in terms of time or inconvenience, then it's not necessary to do it. You can still say you've taken all reasonably practical measures. The closer the harm approaches a fatality, the less weight is going to be given to the cost of trying to avoid it. And in some cases, the balancing act might even go so far as to say we need to stop doing that kind of work because it is just too unsafe. A good example of that is working with asbestos. Okay, our laws illegalized asbestos because we recognize how dangerous it is now. You can't mine it anymore. It used to be this wonderful substance, but we've realized now the cost, the potential harm is just too much. There's no ways in which we can try and rectify it, barring maybe giving all people working with it a spacesuit, which is obviously too expensive. Okay. What is also important from this particular judgment is it explains that the onus resides on the employer, not the employee. So it's not for the employee to go and show, well, you didn't take all reasonably practical measures. It's for the employer to actually explain what they did to actually do so. What is important to also understand that this is a constitutional right. It can't be ceded in terms of a labor broker agreement or a contract or a collective agreement or anything like that. What is also important to understand is that employees cannot be dismissed when they exercise their right to refuse dangerous work. I think that's fairly implicit in the concept. What we have here is we've got some cases that deals with this sort of situation has in fact arisen, which is important, and the cases are in the bundles that I've provided to you. In the first one, we had a situation where someone refused to come into work after a colleague was in fact tested positive. And the employee basically said, like, look, I'm really, really worried. The court accepted the fact that there was an objective danger, and they accepted the fact that the formal dismissal was a little bit too far. Maybe what the employer should have done is try to educate the employee further. Maybe a warning or something like that would have been maybe more appropriate. But in those circumstances, it was not fair to dismiss the employee because they had a legitimate fear of developing the virus because a colleague had already been tested positive at the workplace. In the second matter, and this is a little bit more indirect, this employee refused to go to work, or so-called went AWOL, as they describe it, not because they were particularly worried about their own particular health or themselves dying, but because they were worried about their family members. So in this particular case, I think they had an elderly mother and there was a child which had comorbidities, and the employee was very worried that they might transmit that deadly virus from the workplace to their family. And in this case, again, the CCMA stepped in and said, well, a dismissal is not fair in the particular circumstances, and reinstated the employee. Okay. We've spoken about the right to refuse dangerous work and all these sorts of things. However, what is also important to understand that employees persist in their fiduciary duty to the employer. They need to try and make this work with the employer. They need to work hand in hand as partners with the employer to ensure that the business doesn't go under. They need to basically try and see where they can compromise as much as what they can. And this means things like if an employer were to say to you, I need you to work at home, we need to sort of convert meetings into e-meetings via Zoom, whatever the story is. If they're going to insist that all the desks have to have desk shields and these plastic shields and stuff like that, we have to cooperate. Wearing masks, not only is it a statutory requirement under the disaster management regulations, but I would submit under the OSHA and the Mine Health and Safety Act, it's there already. Okay. As I emphasize, the disaster management, in fact, is amplifying to a certain extent what some of the law already is stating. Okay. This, however, does not mean that employees can just act unilaterally. So we have a case here where what happened was the employer decided that they were going to reduce the salaries of workers that were continuing to work, and they did so unilaterally. The court had to then intervene and step in. They actually tried to interdict the workers from striking based on this issue, and they failed in that regard because the court indicated that the employer was not permitted to reduce those benefits unilaterally. There had to be some sort of discussion and negotiation. Employees can change their terms of employment in discussions with employers, and maybe they should be encouraged to do so in order to ensure the employer is not only there tomorrow, but there in 10 years' time, and they still have a job to come back to. But that has to happen through a consultative process. The employer can't do those sorts of things unilaterally. Okay. What is also important to understand is the employer must also deal with these sort of PPE things and all those sort of regulations consistently. Here we also mentioned a particular CCMA award where what happened was an employee was dismissed because they briefly took their mask off their face during a meeting. The difficulty here was essentially that the rule was not applied consistently. It was applied to the junior employee, but the senior supervisor, who would also frequently do so, was never disciplined. And on that basis, the CCMA said, well, you haven't really applied it consistently, and it's also not entirely clear to what extent they did willfully depart from the rule. In fact, the CCMA said that there was no evidence that they had willfully trying to endanger their employees. They were just trying to be working cooperatively. Okay. Now, obviously, as you've heard, there's a big debate about whether people can be vaccinated or not. I've heard there's a discussion about, in terms of the common law, the inherent conditions of employment. What I need to allude to is that our courts have, to a certain extent, said that you can't apply blanket policies in this regard regarding fitness and to work and these kinds of aspects. There's a particular judgment where a firefighter, or a man who wanted to be a firefighter for the city of Cape Town, applied for the job. However, he was an insulin-dependent diabetic. And the medical doctors had the sort of understanding, general sort of principle that you typically can't use those kinds of people in that kind of hazardous work because there's a danger. The court actually went into it quite in depth, and they called very sort of well-known expert witnesses in this regard, medical doctors and specialists, and ascertained that actually you can't have a blanket rule in this regard for anything, in fact. You need to deal with it on a case-by-case basis. So you may encounter someone who has asthma, but that person's asthma might be so well managed that they in fact run the Comrades Marathon every year. It's not fair to that employee to dump them into the same bucket as an asthmatic who doesn't necessarily have their asthma under control. The doctors are required to look at the particular circumstances of each individual case. Blanket policies and blanket rules are to be avoided wherever possible. Okay. That said, in terms of the vaccination issue, our personal view in terms of our firm is that we would support everyone being vaccinated, barring certain exceptions, and those exceptions we would submit should be based on the opinion, the objective opinion of a registered medical practitioner. with written objections. So if your doctor were to say to you, it's not a good idea for you to be vaccinated, and there may be all sorts of reasons for that, and it doesn't relate to the vaccination itself being problematic. It might simply be that you've got some other condition that makes the vaccination a little bit more risky than otherwise. Maybe you're pregnant or something, I don't know. The doctors would need to assess that. That might be justifiable grounds not to require that particular person to be vaccinated, and we would support that. Similarly, abroad, we understand that there's a lot of challenges in this regard based on religion and belief. Now, we accept that that is also a requirement, and we need to be respectful of those grounds. And we don't necessarily think it would be constitutional if there were to be, for example, a blanket legislation that every single person must be vaccinated, if it's going to be on those grounds. There might be a very much a need to grant certain exceptions to it. So there might be certain people that, because of their medical condition, their age, or whatever it might be, or their religion or something like that, and it would be inappropriate to force this on them. However, we don't really think we know that we're at that stage yet, that the debate has to be had whether this needs to be an act of parliament or our Minister of Cooperative Governance needs to implement it through the act. What we need to do is essentially get enough people vaccinated that we reach what they call herd immunity. This is something that I think a lot of people are also sort of asking about in terms of live chats and so forth like that. The question in terms of remuneration. Now, what is important to understand, and this is where we might depart, and I must admit this is a little bit controversial, and some of my colleagues at some of the big law firms may vehemently disagree with me. But our position is that what you need to do is you need to look at it from the position of what is the employer required to do. The employer has a duty to keep the workplace reasonably practically safe. Okay, so in a situation where the workplace is on fire, naturally the employer is going to say to everyone that they must evacuate, and that does not mean then that the employer can then suddenly say, well, I'm not paying you for that day. Or in a situation where maybe it's got nothing to do with health and safety, but like load shedding and all the computers go out and you can't do anything on the computers, and that's what your job requires. That does not mean that the employers can then turn around and say, well, I'm not paying you for that day. The right to remuneration is not dependent on the actual performance of labor. The right to remuneration is dependent on your availability to perform that labor. So if you arrive at work and the employer simply has nothing for you to do, but you are an employee and they still need to pay for you, it's the employer's responsibility to find you additional work or find a different alternative way of getting you to do something. So if you can't come into the workplace, for example, because of the COVID thing, it's the employer's responsibility to try and make sure that you can work remotely or work in a different way, or try and get enough institutional or engineering safeguards into a place that you can perform it safely.
6 minutes.
Thank you. So what is important to understand is that the employer basically holds the maximum duty in this regard. The employee must simply provide their services, make themselves available. Okay. In this regard, we actually have a case that deals with this kind of situation, where the High Court made the point that I'm making, that it's not based on actual performance, but that they must be able to be there to tender their services. The no wage, no pay principle does not necessarily apply. And I do know a lot of my colleagues, and I'm stating it to be very clear, it is controversial. A lot of my other colleagues would vehemently oppose this and say in the situation, no work, no pay principle is absolute. I don't agree with them. I think that is in a different context to what we find ourselves now. And the judgments that they refer to, I would encourage you to go and have a look at them. The judgment in particular that most of them refer to is the Max Steel judgment. We've given you a copy of it. If you read that judgment, you'll see that the statement about the no pay, no principle is stated in passing. It's not what the court is particularly dealing with at that point in time. And because it's in passing, it's not binding law. It's not what the court is saying. Okay. In this regard, however, what is also important to understand is that in terms of high-risk occupations, as I've indicated, there is presumptions that kick in. So if you are a nurse, for example, or a mortuary worker or an underground mining worker, I would submit, under the DMR's guidelines, and you get diagnosed as positive, there's a presumption that kicks in that it's occupational. It would be wrong for an employer then to go and deduct that sick leave from their sick leave ordinary benefit under the Basic Conditions of Employment Act. Section 24 strictly prohibits it. Okay. What is, however, also important to understand is that you can't discriminate on a blanket approach. Vulnerable workers, employees. So we're talking about these persons with comorbidities. Maybe you're someone who's 61 years old. Maybe you have a woman who's pregnant. Maybe you have someone who's suffering from diabetes. Maybe there's even HIV, or some sort of other lung disease, silicosis or asthma, whatever the story is. It is important to assess that person to see how they are, to understand where they are and how best they are able to cope and function. It's not acceptable simply to dismiss them or to incapacitate them. One of the things that I've encountered in my practice quite frequently is a situation where pregnant women are declared permanently disabled by the medical doctors on the mines. Now, I may be a man, but I don't think that pregnancy is a permanent condition. It usually ends. Hopefully in good circumstances, but I mean, it's certainly not a permanent condition, and it actually constitutes a gender discrimination issue as well. We need to be very careful of that, and we need to always make sure that we put the employee's interests first. When dealing with an occupational medical practitioner who have this sort of dual duty, they have a duty to the worker as a doctor and a patient, and they have a duty to the employer as an employee. It's important to understand that their ethical duty is foremost to the worker as their patient, not to the employee. They need to try and step forward and help the worker as much as what they can to ensure that they can be accommodated as best as possible. Okay. What I also just want to say in terms of that last regard is that what is important is when there's a conversation that has to happen between an occupational medical practitioner and a worker, when the occupational medical practitioner is not completely certain, I beg your pardon, I see my system is frozen, but while the occupational medical practitioner is not completely certain about to what extent it is going to be this realization of this risk or this harm, there must be a conversation with the worker. Ultimately, the consent and the decision of what's going to happen is going to rely with the autonomy of the worker, and it's critically important to educate the worker rather than to take sanctions against them or to do something that might impair them. Okay. We've already touched on a little bit from the first and the second speaker in terms of the COIDA issues. What I want to simply emphasize, which has been admitted, is the fact that the COIDA is a constitutional right. What that means is it's not just an ordinary right that you have, that you might have with sort of a person to buy your lunch from or something like that, a contractual right in that regard. This is a constitutional right that cannot be ceded, compromised. There's even case law to suggest it cannot even prescribe, okay, which is a legal concept. What is important to understand is, in terms when this right arises, is it's not related to the geographical place. So, for example, if you are doing a particular kind of work that might mean that you're quite transient, you have to move around a bit, or maybe just because of COVID, you're not where you ordinarily would be doing your work. What is important is whether you obtained, in this particular case, the medical infection, the COVID infection, in the scope and course of your ordinary work. Okay, so if you are doing something that you are doing for the profit or for the benefit of your employer, and during that time you become infected, then it would be regarded as occupational. There are directives that have been pointed out that relates to how do we assess this and confirm this. Obviously, what is required is a positive test result. A PCR test is sort of a benchmark test there. You might find that a doctor will turn around and say they don't think you have COVID. When the PCR test comes back and says, well, actually you do, it's the PCR test that's probably correct. And I suspect that the doctor, having sight of the PCR test, would probably change their mind or have to sort of work out what's going on. Okay. What is also important to understand, and I see that some people have asked the question, well, what happens if my employer just refuses to report it? They don't believe it's occupational. Presently, and I say this presently because there is a bill before Parliament that is going to change a lot of this and a lot of what I think the first speakers also discussed. Presently, the law is that if you fail to report it, it constitutes a criminal offence. If the bill is passed into law, it will become a finable offence, meaning it's not a criminal act, but a civil thing. There will be a fine penalty. What is being hotly debated there is the amount of the fine. I think presently the fine is regarded as a bit excessive by most people who have made representations in that regard. What is important, and this is, I'm saying this, and I defer this entirely to the medical doctors, I stand to be corrected, but there's this concept of this long COVID. Now, presently, I have not had any experience myself of any long COVID permanent disability claims. Most permanent disability claims under COIDA have resulted from someone passing away in the scope and course of the employment, and widows obtain the benefit. However, I suspect in the future, once research and doctors have got more certainty around this and they understand what is actually going on a little bit better, we are probably going to encounter claims where someone has been permanently potentially affected by the COVID, and that may result in a permanent disability compensation claim under what's referred to as Section 49(2). What I would encourage and recommend to everyone is if someone feels that is in their scope or in their environment, or it might be applicable to them or someone that they know, it is critically important to keep all the medical reports. So if you go for a scan, keep the scan. If you go to doctors, keep all those doctors' information in those reports, because that is going to assist the compensation fund and Rand Mutual, as well as the medical doctors that deal with the issue enormously in trying to understand what is actually going on. Okay, I suspect there's going to be a great deal of development in this regard, and I can't really say much more than that. What I do want to just point out is, and I think I've alluded to it already, is that there are certain rights that mine workers have in terms of their comorbidities under that act. So if they have TB or pneumocyosis, which is silicosis, and one of those diseases, they do have a benefit in terms of statutory medical assistance. What they can also get from that is that they're entitled to sort of a biannual medical surveillance test. So they can go and say, well, I need to be looked at and stuff like that. That is important, not necessarily just for COVID. I'm simply emphasizing that because that is something that a lot of mine workers don't take full advantage of. What is also important is that under the ODIMWA, they also have an autopsy benefit. It may not directly be related to the COVID, but may indirectly in the future somewhat help them in the event that someone passes away and there's a big debate about whether this was from COVID or not. That may come to their assistance in some regard or not. Okay. In conclusion, what we can establish is that essentially our law currently has a lot of instruments already, even prior to the outbreak in the pandemic, that deals with these kinds of issues. In actual fact, I would suggest that if employers, lawyers, employees, and this government were complying with the law very strictly, as I think the previous presenter suggested is probably not the case, and I would agree with. If we were actually complying with all of those things, including, for example, the ergonomics regulations under the Occupational Health and Safety Act, that specifically specifies that if there's a hazard in the workplace, you might need to take ergonomic actions, which might include putting up a face shield or a desk shield or whatever. If we were complying with all of that, we'd probably have far less of a culture shock to this pandemic as what we currently already have had. So I would submit that what we need to do is we actually need to enhance our existing legislation so that we don't need to resort in future to disaster management stuff to fill in the gaps, although that may still be important and necessary to highlight what is important in terms of the law and also to close the gaps where they may be found. What I also want to emphasize is the fact that it's the employer that is foremost responsible for the safe work environment, but that the employee does have a part to play there as well. And what is critically important is to understand what this concept of reasonable practical measures means. It means that you need to be able to balance those things on a scale. In the event that an employer realizes it's going to cost them millions and millions of rands to keep their employees safe, and that is going to bankrupt the company essentially, maybe then the business needs to decide, well, maybe they're going to stop doing business or something for that period at least, in order to avoid the harm. Okay. That said, there needs to be a very delicate balance between these health issues and the economic health issues, because if all of the companies are just going to shut down and go bankrupt, like many of them have, ultimately that's also going to have a detrimental health effect to the employees. You may not, as I think the previous speaker alluded to, you may not go without a salary presently, but you may go hungry later on because your employers had to go bankrupt or something like that. So there is a need for compromise in these situations. We need to accept the fact that we're dealing with a situation where it's fundamentally about the social democratic communal issues rather than just the liberal individual aspects. Okay. Thank you very much.
Thank you very much, George, for that detailed presentation. We have run out of time, and I'm going to ask the attendees who've got a question that might still be there in the question answer box. We're going to give our presenters, say, another few minutes just to go have a quick look at the questions there. George, if you could also have a look there. But this is where we conclude today's webinar. We've had over 100 questions answered. Almost 120 questions in total, and we've had a great input by the following speakers, and that's Ms. Nokuthula Sihlangu, who's on behalf of the Compensation Fund in the Department of Employment and Labour, dealt with the compensation for COVID-19 in the workplace and laid the basis for our two presenters who followed. And the second presenter was Dr. Jan Napier, the occupational medicine doctor, as well as a specialist consultant in health and safety and the social aspects of occupational health at the workplace. And he dealt with the compensation for COVID-19 in the workplace. And then finally, we have Mr. George Khan, who is a senior associate at Richard Spoor Incorporated Attorneys. And with his two colleagues, I think it was God knows Mudimo, and I just missed the second colleague's name there, who had prepared and delivered on the topic COVID-19 rights and duties towards a better understanding of the law. So thank you very much, everybody, for joining us today. We dealt very thoroughly, and our three speakers have done an amazing job in dealing with the details of the rights and obligations and responsibilities that is laid out in terms of the broader legal framework, constitutional, national, as well as the specific laws applicable to compensation in both the mining and non-mining sector has been touched on briefly. And you've asked all your questions in the Q&A box, and thank you for that, and for our presenters to have taken so much time in answering the questions there as well. So hopefully you have learned more than what you expected. The presentations will be shared with you. The links will be uploaded, and the links will be distributed. Like the CPD test that will be done online for those who are interested, that link and password will be distributed. We'll be distributing to you also the link for the post-webinar feedback we want you to give us on the webinar, an evaluation form of sorts. So thank you very much to Ms. Sihlangu, Dr. Lapierre, and Mr. Khan and colleagues for your contributions. If I could just ask the colleague, Ms. Sihlangu and Mr. Khan, just to have a quick look at the question and answer box, and then we'll close in a minute or two. Thank you very much. See you on at our next webinar, and that webinar is going to deal with occupational health and safety, workplace systems, and COVID-19, and the invite will be circulated soon. It is on the 27th of May, yes, and there are the other ones that you will receive your invitations to. Thank you very much. See you at the next webinar. Goodbye.